Good morning, everyone. Thanks so much and welcome to our class today. We're going to do a little bit of an introduction to Maryland real estate contracts today. I'm excited about this. We have people in the office here and also a whole bunch of people on Zoom. So thanks everybody for taking time out of your day to make sure that you can represent your clients effectively. My goal is always to try to raise the level of professionalism in this industry. So I really value and appreciate people that take the time out of their day to make sure doing things the right way. So why should you listen to me? My name is Doug Rubin. I am an attorney. I am the broker here at Keller Williams Legacy. I am a member of the State Forms Committee, and I'm also a practicing realtor myself. I don't do a ton of business because I help a lot of other agents help their clients, but all these things I think are helpful in different ways, right? So hopefully I went to law school. I can hopefully help you all understand as we really get into the nitty-gritty of some of this language and some of the addenda. What really helps is this State Forms Committee, right? So if you don't know how this works, every October we get bombarded with these new updates, right? That a whole bunch of folks get together on this Forms Committee with the Maryland Association of Realtors, and we workshop different ideas that people propose, changes that we need to make. Also, as new legislation comes down every year, that always requires us to tweak the forms a little bit. So I'm often kind of on the ground floor and participate in some of the discussions around some of these changes, right? So I can hopefully provide a little bit of extra context. And also being a broker is fun, or maybe not so fun, because people come to me when they're about to get sued or deals are falling apart, right? So I spend hopefully more time than y'all digging into the gray areas and really the nitty-gritty stuff that is a little bit more complicated or problematic, right? So hopefully, I can impart some of these lessons learned to you all so we can be better representatives for our clients. Sound good? Okay, great. Whether or not it sounds good, we're going to do it anyway. There are a couple of bright red slides I'm going to go through. TCPA is so scary that I really don't even advise that people cold call in any capacity in their business. I think it's generally a bad idea. If you're going to do it, talk to your broker, talk to a lawyer. It's really complicated to try to do it right. They make it really complicated to discourage people from doing it. Same goes for the CAN-SPAM Act. If you're texting or emailing, you need to make sure you have opt-out procedures and you're tracking things. And so it's pretty complicated. So if that's part of your business, make sure you do it right. Please abide by fair housing. I will highlight that buyer letters are essentially illegal in the state of Maryland. These are the love letters that people write, like, no, I really want your house, which is great. I received one of these the other day for one of my listings. I had to delete that completely before I send it to my seller, right? Because what we don't want, even if it's on accident, my white Christian family is really interested in your house, right? Like, even if it's not so overt, we need to be careful about that kind of stuff, right? And the big one here is that part of understanding the contracts is how to understand sort of how we get paid and how we discuss money with our clients, right? You may be aware a couple of years ago, there was a big freaking lawsuit that changed a lot in our industry, which required the NAR to settle, basically conspiracy claims that all these brokerages are coming together to set fees and rip people off, right? So fees are negotiable. I am not proposing that we all agree to set fees. There may be a scenario in a couple of situations where I'll throw out a number for purely example purposes and we can kind of run through math, but I'm not interested in setting rates. And actually within our particular brokerage, lots of people charge different rates depending on their value proposition, their relationship with their clients. So make sure that if you have questions, maybe your brokerage handle things differently. So we're basically not talking about commissions in any kind of concrete way. Okay. Does everybody know how to log on and get to the Maryland Association of Realtors website?
Yeah.
Okay, good. If you don't, figure it out, okay? Because this is going to be kind of the mothership for your forms that you're mostly going to care about. So when you go to the forms section within these legal resources, they actually provide a couple of different links here. So they provide something for local boards and they provide the statewide forms. I would expect pretty much everybody here is a member of a local board, okay? In my brokerage, it is required that you're a member of the local board. This is what gives you access. You pay the local board a whole bunch of money. They pay for you to be a member of Maryland Association of Realtors and also the National Association of Realtors, right? This is our code of ethics. This is our forms. This is our disciplinary avenues. Like, so the whole system is kind of built upon being a member of these boards. In Maryland, perhaps especially, we do have a lot of local nuances. We're kind of we're an interesting state where different portions have different real estate risks and realities that will all have their own addendum. So at the kind of bare minimum, we need to understand that depending on what county you're in, there's going to be at least one form that you're going to need. So I'm right now in Baltimore County, closest to Baltimore City. So we do a lot of business. There's a Baltimore City notices and disclosures. There's a Baltimore County notices and disclosures. That's going to be, there's going to be a similar kind of document if you're in Anne Arundel, Worcester, like Charles, wherever you're going to be, right? So dive into these local boards, but be careful if you're only getting them from the MAR website. It says right here, like, basically, we can't promise that these are the most up to date. If you're a member of your local board, you'll have the more fulsome library of those local forms, and you'll know that those are going to be updated. So if you have any questions, or if you do a lot of business in a certain jurisdiction, think about joining that jurisdiction to get access to their forms and access to their resources. Okay, so just wanted to highlight that quickly. Most of the stuff pretty much everything we're going to be talking about today is from these statewide forms, and this is the committee that I'm on, right? So I'm just going to dive in here so we make sure we all understand what it looks like. The couple things that I'm going to highlight, they actually, every year, I already mentioned in October, they make little adjustments, right? They actually provide a summary of changes document and little like worksheets essentially that let you know what changed this past year. So if you're here because you maybe have had your license for a while, but took a year off for family reasons, or you're kind of getting back into it, go through and make sure every year there are changes. Some of them are really, really big. Some of them are not so big. Just make sure, talk to your broker, go through all the resources that you have, but also take advantage of what's on MAR. So there are a lot of good stuff there. Okay, with all that, and then basically they just have, 200 forms in there. Everything is here. This is what propagates out to Dotloop, DocuSign, zip forms, whatever you guys use, right? So, but this is, if you ever have questions about what is the most updated version, what I like to do, like, oh, if you're looking at the additional as-is provisions addendum, and you have a dated document on zip forms, I can cross-reference the MAR website and say, okay, the most recent one was updated in 2023. So this is going to be how you can cross-reference things. Okay. I am teaching Maryland contracts today. I have 90 minutes to do that. I will not be going through every paragraph of every single one of these documents, right? So the way I like to do it to make it the most useful, I'm going to spend a little bit of time on the brokerage agreements, both the buyer and the seller. I'm going to discuss the big changes that have happened more recently. I'm going to talk about how we get paid. And then I'm going to go into kind of the heavy hitting documents. I'm going to go into the contract of sale. I'm going to go into the inspections, the financing, kind of the big contingencies that are going to be in most real estate contracts. I'm going to try to highlight a couple things that just come across my desk more frequently, so you can all be kind of a little bit more just educated and aware of things that are going on. And we're going to open it up to questions, probably at a couple of different distinctions. So just general kind of Zoom courtesy. I'll ask that everybody kind of stay on mute just because there's a whole bunch of people in this room today. And then at different instances, I will invite people to ask questions. We have people helping me sort of supervise the chat mechanic. I'll consult that. And then there may be moments where I'll say, okay, if anybody has any questions, now's the time to come off mute and people in the room can shout out what they need. And just maybe one more piece of introductory. Now is the time where we are seeing more lawsuits and complaints and mediation requests than ever. I promise you, brokers that I'm interacting with, big team leaders or people at the regional level, they're all saying, I've never gotten a complaint before in my life, but now I've received 3 in 2025. These sorts of things are happening. I can't entirely explain it, but people are more kind of frustrated and angry, whether it's at us, whether it's at buyers, whether it's at sellers. Prices are high, interest rates are high, and there's a lot of pressures that are creating frustration points. And all of that ultimately means that we need to button ourselves up to protect ourselves, to protect our brokerages, and just making sure we're providing an even higher level of service and providing even more level of expertise than we had previously. So that's kind of the background. Okay. So now we all understand that all this stuff is super important. Okay. All right, I'm going to dive first into the brokerage agreement that you need if you represent a seller, right? So this one is probably one of the more dense documents that we're going to go through today. So this is if you have a listing, right? You have a listing, you bring this to the seller. I'm not going to go over the top bit. You're going to make sure all the contact information is going to be filled out. You're going to make sure that the address is here properly. You're going to ask the seller if the house is owned in fee simple or if it is subject to ground rent. For those that may not know exactly what ground rent is, I'm not sure anybody knows exactly what ground rent is really. It is the most bizarre thing that basically only exists in Baltimore City. I think there's like 3 places in the country. It's like Baltimore, somewhere in New Jersey, and Hawaii. Something it's very niche and confusing. It becomes a giant issue if you work with a lender that does not understand what these things are, right? So deals fall apart when they see ground rent and they don't know what it is. But basically, it's just a crappy fee that an owner has to pay on an ongoing basis to this sort of mystery person or mystery corporation that owns this kind of monetary interest in the land. So it's really important. This does come up a lot if there's confusion around ground rent. So make sure you ask in a really pointed way, Mr. Seller, is this property subject to ground rent? And they need to tell you, the broker, the realtor, and we rely on that to some extent. You can also check the land records, guys. It has to be in there. Sometimes it's a little bit hidden, sometimes it's in there, but it's not registered property, so it can get kind of icky. And that's where relying on really good title people, really good lenders are going to help you out as well. So that's just one kind of nuance that we need to deal with in the state of Maryland, and you need to make sure that you are comfortable having the conversation. Okay. Every single agreement has to have a beginning date and an end date. They cannot go on perpetually. In fact, they just updated it. I want to say a year ago, where they say the agreement may not be longer than a year in duration. Okay, there was kind of this notion, and there were some bad actors that were kind of locking people into these like perpetual listing agreements where say, hey, you have to sell with me even if it's 10 years from now. It's really important that we're never binding people to longer than 1 year. This includes extensions, which is kind of annoying, right? So we used to do 1 year, and then maybe you could just do a little addendum that says extend. Every year, guys, you need a brand new listing agreement. Okay, so you could do a 6-month term, extend that out to a year. But once you get to that year and you want to continue working with these people, you need a brand new listing agreement. Okay, things may have changed. It's good practice anyway to remind everybody about the obligations. You are also required to insert terms of termination. Okay. We are a fairly protective state in terms of allowing people the right to get out of this particular agreement. So the way that I do it is, let's say, unilateral written notice within 3 days. So I like to put in some period of days, so it's not just email, you're fired. It could be email, but a contract is about to come in, or it gives you the opportunity maybe to do one more open house and try to get a contract. So honestly, I'll even give you some language that I use. I say unilateral termination with 3 days written notice. But I like to have something about unless you are already under contract. That would be crappy and kind of confusing if you're under contract and they can fire you. That would sort of require a lot of machinations and explaining. And so basically my position is once you're under contract, it would require a mutual release, which you can always do, right? If both sides agree, let's get out of this, contract over. But we also like to put in some kind of a mechanism for unilateral termination. Okay. You also need to put down a listing price for this document to sort of be complete. This can kind of be an uncomfortable situation depending on where you are in the stage of your consultation with your sellers. If this is the first time you're meeting them and you want to get that document signed right away, that's totally fine. But I may then have the conversation that, look, this can be a placeholder potentially, but if it does change, you need to make sure that you're documenting that in writing as well. Because Bright has things to say, our local MLS. We can't go willy-nilly just changing list prices on the MLS. We need to make sure that it's all documented and there are mechanisms to do that. Okay, showing instructions. This is just an opportunity to have the conversation with the client. Is this going to be vacant? Is it going to be marketed as go and show? Is it, are there pets that need to be secured? Are there certain times of day that we need to block off as not being available? So this is where you would kind of go into all of that, in addition to talking about what type of lockbox you'd like to use, that sort of thing. The next kind of material part, and I don't love really the way that this is structured, where basically I encourage people to skip a couple of sections in most situations. So paragraph B here is about this office exclusive concept, which is a little bit of a hot button in the industry. Some people are really pushing this. There are limited situations where this is maybe in the best interest of your seller, and they really just want to kind of have informal marketing just with you, their realtor, without putting it broadly on the internet, without putting it on the MLS. If they wanted to do that for whatever reason, they would need to sign here, initial here, and then there's also an extra addendum that they'd have to sign to make sure we're checking all the boxes to Bright. So if they're interested in that, there's some extra steps. If there's not, you just skip B completely. Section C is similar, where there are really specific situations where this might apply. If there's this like hyper-vigilant privacy risk, or you're working with a celebrity or a high-income person that maybe doesn't want their address to be published, or they don't want it on the internet, they just want it kind of through your personal catalog. So in those situations, the seller can initial, hey, don't put it on the internet, don't allow the property address to be on the internet. So they could check those, but for the most part, you're skipping C, right? I want my sellers to have as much exposure as possible, and that includes having their address out there. Wouldn't that be helpful if you were buying a house? So oftentimes B and C are just going to be left blank unless it's a really special situation. Okay. The next section is a little bit confusing. I kind of call these the like Zillow paragraphs, where they can authorize or not authorize this concept of comments or these automated estimates. They're talking about Zillow essentially, right? To use their Zestimate or whatever, all the Redfin has their own estimate, they all have their own kind of AI BS that they like to use. But for the most part, that's kind of the game we're all playing, right? I want my listings to be on Zillow and Redfin. So I generally do kind of authorize these or encourage the seller to authorize those if they want kind of unimpeded access to all the third-party sites that we kind of rely upon. The next discusses the listing status of coming soon. I think this is a good tool. It basically allows some pre-marketing where you can say, hey, this is available. It's not ready to show yet necessarily, but hey, it's going to be available on X date. Go ahead and set, mark your calendars, or you can start to schedule it out. So it's a situation that generally I'm encouraging my sellers to check this box off in case that in case that the stars align and the timing makes sense and we can take advantage of that bonus marketing. Does anybody know how long you are allowed to have things in coming soon?
3 weeks.
Unlimited.
You're unlimited. The answer used to be 3 weeks.
Oh, okay.
It did change, I think, last year. They basically took they took it away to give us a little bit more flexibility. I don't really know why you'd want it to be longer than 3 weeks. You could hypothetically have it for 6 months. You could have it coming soon for a year.
That's not soon.
But that's not right. That's not soon, first of all, and it's not helpful because people just forget about it, right? But that is a distinction that I like to, because that was scary before, where let's say you're waiting for the seller to finish painting. It takes a little bit longer, but if it got to the 22nd day, it used to click over to active automatically. So it won't do that to you anymore. So it gives us a little bit of breathing room now. So you can kind of make it be whatever date makes the most sense. So they'll just initial saying that they understand that. The next session is about, are they willing to consider offers of concessions or credits? Most sellers, I think, are saying yes to this, just like, oh, I'm not bound to anything, I'm just willing to consider it, sure. So, I think that I don't really like this section being in there. I'm not sure that it actually says anything, but it invites us again to have a conversation about, hey, there may be buyers that are going to ask for these credits, right? So let's at least kind of be prepared in that instance. The next kind of weird one that's arbitrarily boxed and bolded is this concept of discussing other properties in the event that you're holding an open house. I generally, when I'm talking to my clients about it, I'm basically saying like, hey, if someone asks about the house down the road, I like to be able to discuss it, in part to say how much better your house is than X. But there are some sellers that are like, you represent me, you are at 123 Main Street, you do not talk about 124 Main Street, like that they're really worried about this conflict. So sometimes they'll say no. And that's fine. That's just something that needs to be respected and understood, but just have that conversation with your sellers so that there aren't any surprises. And also, like, we are the fiduciaries for the seller. I understand that open houses are great for lead generation. You can pick up some buyers, but that's for later, right? That's not what you're there for. Your primary duties are to the seller and to the seller only. And make sure you explain that to the seller if they have any questions about it. I always highlight paragraph 10 here. State of Maryland requires, what is it, two-way consent. One person can't just secretly record you, right? So especially, but this is limited to audio. So like Zoom, like not the Ring cameras don't necessarily need to be deactivated, right? But if they have a nanny cam that's recording audio, that is illegal. That is a problem. So just say, hey, do you have any home surveillance that records audio? Yes or no? Okay, make sure you disable it, at least for the showings. That's really important so they don't go to jail. That's part of our jobs, to keep sellers out of jail. All right. Comply with fair housing. You have to have insurance the whole time. If the buyers ask for a licensed contractor to perform repairs, you need to actually get a licensed contractor to perform repairs. Okay. Let's figure out how we get paid in real estate. You'll notice bold language, and this is everywhere after this lawsuit. Commissions are not fixed, rates are negotiable between the buyer, or between the seller and the broker, in this instance, talking about the listing agreement. We are allowed to set forth our brokerage fee in one of three ways. We can do a percentage, we can do a flat fee, or we can do some combination, a percentage and a flat fee. And this is going to be the total commission, guys. 14 is the total commission that the seller is paying. And then later down the page, we'll talk about potentially sharing that with a cooperative broker. Okay, so I'm just going to say 7%. Okay, for funsies. This agent wants to charge 7%. That is their fee. They could say, my fee is just $10,000. You can run your business that way. It doesn't have to be set to a percent. In fact, I've always wondered why it's set to a percent. Wouldn't it probably is more rational if it's set just a fee? People can absolutely do that. That's really common if you're working for low dollar investors, if they're buying like shells of house for $40,000. Maybe that's not worth your time to get 3% of $40,000, and maybe you want to make sure you get at least a couple grand. That's how you would put that in. Or number two is common for the brokerages that say, I'm charging a percentage and an admin fee or a broker fee. You could absolutely do that. Two kind of warnings. One, the CEO of Maryland Realtors hates that. He's not saying it's illegal, but there are often questions, and it does kind of invite complaints. Why are you charging an admin fee if you're already charging this percentage? What the hell is the commission for anyway? So if you do put something there, so the second one is, you better have an explanation for it, right? If you're gonna ask for a fee, that's going to invite questions about that fee. So just make sure you can explain what you're charging and why you're charging. Okay, so this is where you set your fee. We are a professional providing a professional service. We are setting forth the fee. Okay, let's pretend this person is charging 7% of the total purchase price. In the event of sale, compensation to be paid by the seller to broker shall be 7%. Okay. Slightly down the page, I like to call this the "don't screw me over" paragraph when I'm working with a buyer or a seller. That says, hey, look, if we're working together and a buyer makes an inquiry or I bring a buyer to you, you can't just fire me at the 11th hour and try to save on the commission and work directly with that buyer. Like, the contract protects us from that. So I have the very candid conversation of like, we're on each other's team, like, let's not try to backstab each other. And most people kind of chuckle and say, okay, yeah, that makes sense. So you can kind of put whatever number you think is easily explainable. You can put, 2 weeks, you can put 6 months, you can put 60 days, 90 days. These are kind of the numbers that I see. And this just says, like, again, if I've already brought you this buyer and you want to work with this buyer, if he comes around next year and wants to buy the house, I don't have a claim to that. But if I'm saying within 90 days, you can't just fire me and turn around and sell this property to that person. Okay, so that is a little important protection that I do like to bring up. Okay. For, let me just see. Okay, so the next paragraph is about cooperative compensation with other areas. So this is the paragraph where we say, hey, if there's another broker or another agent that works for another brokerage that brings a buyer to you, Mr. Seller, we agree to kind of split this commission in some way, or the seller is consenting and agreeing and basically mandating that we split this up in some way. The splits are not mandated by anyone. The numbers are not mandated by anybody. But remember, in this kind of example, this agent is charging 7% total on the listing side. So that's what the seller's paying. So there, here in paragraph 15, you say, okay, so if somebody does bring you a buyer and wants to buy this house, what are you willing to share? Or what are you directing us, the listing agent, to share with the other side? So let's say in this instance, they go through it and they say, okay, if a buyer is brought by another brokerage, we'll give them 3% out of the original 7 that we've already talked about. So for easy math, the listing agent would be getting 4%. The buyer agent would be getting 3%. You notice there are 2 different sections here. This is a little bit confusing and becoming almost obsolete, but it's 2 different technical characterizations. There is a sub-agent that could bring you a buyer, or there's the buyer broker that could give you a buyer. In most instances, you're working with a buyer broker. That person has a buyer agency agreement with their client, right? In fact, they're essentially required to. One of the conditions of the most recent lawsuit was that a buyer agent isn't allowed to show a house until they have a buyer agency agreement executed. Sets forth their fee and lays out that fiduciary relationship. So in almost every instance, you're going to be dealing with a buyer broker if there's an agent involved at all. This concept of a sub-agent is basically this kind of floating agent that doesn't really have a buyer agency agreement and is therefore technically representing the seller. But most people, when I see these documents, these fields are going to match. I don't really care, or the seller doesn't really care who brings the buyer, if they have a brokerage agreement or not. If they're willing to share 3%, they'll share the 3%. Okay, so again, we're just throwing in numbers for fun here. We're not mandating that anybody charge this, but this is how it would be broken down. So paragraph 14, again, is the full commission amount that the seller is being paid. And then if a buyer agent comes along, the sale culminates, and they request the commission to be shared, paragraph 15 is what you would share with that agent. Okay, everybody with me so far? That's really the meat of it. I always like to kind of mention have you guys seen the little sheet of paper about the smoke alarm laws? That's super confusing. If it's the house is built X, then they need to be wired. If the house is built Y. So I always like to say basically that the seller has a responsibility to make sure that the smoke detectors comply with the laws. Like that's something that the buyer doesn't have to ask for, the seller just has to do it. Okay, so I always kind of warn my sellers that it's something that they're going to have to do either way. If the house is built prior to 1978, you need to check the right box and then understand that that's going to trigger certain lead paint disclosures. Okay, 1978 is the magic number. If the seller isn't sure when the house is built, then by law, we have to assume it was before 1978, and that triggers the federal and state disclosures. Okay, if it is before 1978 and certain repairs are required, you may have to jump through a couple extra hoops, according to the EPA.
I have a quick question if I'm able to ask. Can you hear me?
Go ahead with the question.
Oh, okay, yeah. So if the house is sold as is, do we need to change the smoke detectors as well, or can we just leave it the way it is?
Sorry, I didn't hear the first part of that question.
If the house is being sold as is, does the seller have to change the smoke detectors and update it, or because the house is being sold as is, it's just gonna be left like that? Gonna be left like that?
I need to look again at the language. My understanding is that it's separate and apart from anything that the parties agree. That the state has decided that it's so critical a safety feature that it's something that the things have to do regardless. I don't believe that it's waivable, but that's something that you need to really check with. I would check with the legal hotline with MAR. And it's something I can do a little bit of research on, but I would be very careful. And I have seen a dispute about that. And what's funny is that once it's disputed, it almost doesn't matter who's right. Like, if the seller says as is, and the buyer says, okay, but you still have to comply with smoke detector laws, and they refuse to go to the closing table unless smoke detectors are installed, you're gonna have to figure that out sort of one way or the other, just to get it to the closing table. Or if that winds up blowing up a deal, then there's no easy answer as far as how that EMD is going to be released and how that's sort of resolved out in the back. So from what I understand, I think it's basically unwaivable. And maybe you can build in some language that specifically says, seller shall not repair or replace smoke detectors. But honestly, I can't promise that that's enforceable based on the smoke detector laws that are in effect. That is
Okay.
excellent.
Thank you.
Thank you. Okay. So we went through lead paint briefly. All right. If you guys ever see something called a front foot fee, sometimes referred to as deferred water and sewer fees, these are when builders are putting together these developments. And they say, oh, we probably need like sewer lines and water lines and that good stuff. At some stage, they figured out that they could basically bill all future owners to pay them back for that, which is truly a great deal for the developer. So what they literally do is record something on the land record so it attaches to the house, not to a specific owner. So any owner of that house for the next, let's say, 30 years, they have to pay $600 a year towards that fee. Okay, this is generally kind of a separate bill that the seller is going to receive. You know, it's not usually lumped into escrow, though maybe it could be. And this is something that's really important that we have a conversation with the seller. Do you have this fee? There's a disclosure addendum that we need to provide explaining this fee, who it's paid to, how many years are left on it. And here's the deal, guys. If the seller doesn't disclose this at the outset and it goes to settlement, the seller shall be liable to buyer for the full amount of any fee or assessment not disclosed. So this is a big deal. If the seller is not sure, they need to figure it out, and you need to point to this paragraph and say, are you really, really sure? Because this would be really expensive for you if you don't get it right. And this again is something that you can check on the land records to try to help your seller out. It has to be recorded in the land records or it's not a valid assessment. So make sure you have that conversation because that's a huge monetary issue if they don't figure it out. Okay, paragraph 21. Are we given authority to disclose existing offers? There are a couple of different ways to kind of handle this. It comes down to personal negotiation style. I like to at least get consent to share this information. My favorite words to say as a listing agent are best and final, right? I have received offers, send us your best and final. So that's an extra kind of arrow in my quill to get the best possible deal for the seller. Okay, so I usually suggest they authorize that. If your brokerage offers a home warranty, they need to notate the correct spot. Okay, we're gonna spend a minute right after this going over the disclosure and disclaimer statement. But basically here you need to have the conversation. Are we exempt from the disclosure and disclaimer? Or are we not exempt from the disclosure disclaimer? Most cases, guys, we are not exempt. And we're gonna need to fill out these forms, okay? I'll go over the exemptions on the next document that we go through. But these are fun forms that we should all be familiar with. Okay, if there are conservation easements, it's sort of a yes or no. If yes, they need to mark down, and we rely upon the sellers to understand what's going on with their property. Sometimes the stuff is reported in public records, sometimes it's not. They need to maintain insurance. Please ask the question, are you a Maryland resident? This does matter if they happen to be a Pennsylvania resident that's selling this Maryland house. There are big tax consequences potentially that I don't get into too much, but I say we need to figure this out before we put it on the market because it might suddenly not make financial sense to sell the house if there are extra tax consequences that haven't been sort of fully understood. Okay. Same if they are a foreign resident. A deal almost fell apart the other day because of questions about FERPTA. If they are a foreign resident, according to the statute, there's an extra addendum that you need to fill out as well, but that's like extremely complicated. So check with a title attorney and I've checked with a title attorney that you have a relationship with. If you have questions about that. If you have well or septic, you need to make sure that you mark off accordingly. There are disclosures that you need to do for that. If you're near a Superfund site, this is radiation, guys, your seller needs to disclose about that. Now, these are some of the addenda. Just make sure you go through these, guys. It's just an opportunity to sort of refresh yourself that, oh crap, this does apply, or, you know, I do need to send this along with you. And these are questions like, oh yeah, are there solar panels on this property? Then we need the solar panel addendum. If you checked something about Superfund, then you need the Superfund addendum. If it's before 1978, it's lead paint addendum. Okay. Are there questions about the listing agreement? Yes, from the room.
You're saying.
Hello,
you have-
Doug. Beatrice.
Hey, Beatrice, yes, 1 second. We have one question in the room, and I'll come back to you.
Sounds good.
All right, thank you. Yes, go ahead.
Are you saying you have to fill out the disclosure disclaimer, as most people cross through and then.
Sorry, yeah, I'm gonna get to that. But the question, all I'm saying is, are you exempt such that you don't have to do any of it? Or are you not exempt, so you at least need to
Oh, you
fill
have
out
to do
the
something.
correct
Right,
portion, right?
right.
So we'll
Okay,
jump into that
I misunderstood
momentarily.
what you said.
Yep, well, I'll spend more than a few minutes going over that in about 2 minutes. Ms. Beatrice, how can I help you in Zoom land?
Hey, Doug. Happy New Year to you.
Yeah.
We are seeing the Maryland Lead Poison Prevention Program disclosure checked off a little often. And we had a listing, and it seems like every offer that was submitted checked that off. Is that something that we are now needing to put into our documents about the lead poisoning, even if the property wasn't a rental?
So, no, not legally. So and I can appreciate that, again, we're in mixed company here, right? Different brokerages and different specific offices are gonna have their own policies. And guess what? There's no harm in providing the pamphlet about lead or the pamphlet about mold or the understanding how home inspections work. Like all these things are perfectly fine to pass along. But if the house is built after 1978, there's no required by law addenda or brochures that you have to include. So it's not required, but there may be other offices that say, hey, can we just include this so I can get through my own office's compliance? And then usually I say, sure, you know, there's no harm in including it.
Okay, thank you.
Yeah. All right, any other questions? The listing agreement I know is. It's a
Hi,
hefty
I have
one.
I have a quick question. This is Barb Reamer with Berkshire Hathaway.
Hey.
Hi. I've had a lot of listing agents say to me, "Do you have a buyer broker agreement?" If I'm looking, if I'm putting an offer in. I guess because I'm thinking because they put 0 for the sub agent and they want to make sure that it's not a sub agent. I'm not a sub agent.
So that's interesting. And there are 2 reasons that they could be asking for that. One is they want to see if you're a sub-agent. Yes, and the other one is, and we'll go over this in a second. After the new lawsuit, buyer agents shall not be compensated more than whatever they put in their buyer agency agreement. So if you put 2%, and they're willing to pay 3%, you ain't getting that extra 1%. Okay, so that's the other thing that they may be checking for. Now, personally, I don't believe that the seller has a right to your document that is between the buyer and the buyer broker, right? Like the seller is not a party to that document. So there is kind of this inherent conflict. I wouldn't be surprised if title companies are asking for that buyer agency agreement to again verify both of those things. Do you are you a sub-agent? And to make sure the title company protects themselves so they're not paying you more than they were supposed to. So generally it's kind of like a play nice in the sandbox moment where you can decide, is this a hill I want to die on? Because technically you're not entitled to this document, Mr. Seller. And that may be the appropriate position to take. But if the seller's really pissed about it, they can always go to the title company and say, you know, this transaction can't settle until we kind of figure this out, and then the title company may step in and request that
Okay.
document.
All right,
So
thank
it's,
you.
it's a great question. It's a little bit sticky. Yeah, thanks. Okay. Anything else before we move on to the buyer side? Yes,
Superfund sites.
yes.
What's that?
Superfund sites are literal like radioactive waste recovery situations. So to be honest, I don't exactly know how a seller knows. It's like a geographical boundary, how far away you are from one of these Superfund sites. So it's sort of one of those things where I hope if you're near one, you know that you've been notified that, hey, there's, you know, a radioactive dump 3 feet from your house. And then that becomes something that you need to disclose.
So when you are saying yes or no,
Well, Bethlehem Steel is a Superfund site. Actually, Bethlehem Steel, like all the toxins they put in the water and the land there, but there's a website that tell you where they are and how close, if you put your address in, how close you are to them.
Yeah. For those that couldn't hear on Zoom, like the Bethlehem Steel, the old steel mill was such a toxic to the land scenario when it was sort of demolished, right? And you hear about, you know, there may be a oil leak somewhere, or I think even old laundromats, the kind of chemicals that they use can be like so problematic when they leach into the soil. And then my assumption is that once it's deemed a Superfund site, that would trigger this sort of public notice situation where if you're a seller, you then would have an obligation to disclose that. Yep. Okay, we're gonna go to the buyer side.
Quick
Oh, real quick.
quick question,
Yes,
please.
yes.
So back to the title company being able to ask for the buyer agency agreement. Do they actually have a right to see that agreement, or is that between the broker and the buyer?
So I think again, it probably is just between the broker and the buyer. But I could see a title company saying, okay, you can say we don't have the right to this document, but they're not willing to fund any money to the brokerage unless that document is provided. I could see them taking that position to protect themselves. And then maybe you need to find another title company if you feel that strongly about it. So it's a very strange situation where there's this private agreement between a buyer and a buyer broker. But also there's these enforcement mechanisms that other people can get in trouble if they pay you incorrectly. So again, it's kind of a sandbox moment where my position is, yes, you can decline to provide these documents, but there may be some fallout for taking that position. Whether or not that fallout is justified. I mean, maybe the title company isn't allowed to withhold the money or isn't allowed to delay settlement, but they might do it anyway, right? Because they're worried about their liability.
Thank you.
Yeah. Good questions, everyone. Really appreciate this. We're gonna spend just a few minutes on this very fun document. So Maryland has pretty broad. Actually, let me take that back. The document is broad, as far as what our obligations are. It's in terms of sellers making some disclosure. Okay, so we have this combined document that's so fun called the Maryland Residential Property Disclosure and Disclaimer Statement. Okay, the and is important. This is basically 2 documents. Okay, there's a little notice period, and then the first one is the property disclosure statement. Okay, so this is page 1, this is page 2, this is page 3. This goes through, seller, please verify that your plumbing is good, that your HVAC is good, that there's no standing water. Really sort of micro level detail of disclosure. Okay. This is sort of the going above and beyond, being as transparent as possible and really explaining everything about your home. Some people like to fill this out because it's an opportunity to brag about their home, right? Roof new, plumbing new. There used to be a sump pump issue replaced 2025. Like, that's all actually great stuff that should give maybe a potential buyer a lot of confidence that the house has been well maintained. So much so that they might waive an inspection or they might kind of change the parameters there. So there are strategic reasons why people might fill this out. The other option, which I have to say is more often taken, is the page 4, which is the property disclaimer statement. So please don't fill out pages 1 through 4. You either do 1 through 3, the disclosure, or page 4, which is the disclaimer. The disclaimer sort of says, if you read it quickly, buyer beware, get an inspection, figure it out yourself. With one important caveat. The seller doesn't just say, good luck, the seller still has to say, if they have actual knowledge of any latent defects. Doug, what's a latent defect? I'm glad you asked. It's right above this. So go through this with your client. It is defined as a material defect in real property that a purchaser would not reasonably be expected to observe and would pose the threat to health or safety. So it's at least sort of hidden and it's dangerous. Okay? That means mold. That means faulty electrical stuff. That means moisture intrusion through the roof. Stuff that someone casually walking through in a showing, in a 10-minute showing, isn't going to be able to find, right? But obviously would impact the amount of money that they would be willing to share or willing to pay for the property. And honestly, is so dangerous that the seller is required to do this. Okay. This is where we need to have potentially a hard conversation with our sellers, where they check no latent defects. So like, hey, are you sure? Because this is how you get sued. If they have any knowledge of standing water occasionally in their basement, or oh yeah, the roof drips sometimes, but not that often. It is not. So I said jokingly, our job is to keep our sellers out of jail. Okay, that's how I position this. It's not me being a narc and making their lives difficult. This is me saying, I promise you it's not worth it. If they find this out later, it's going to be a much bigger problem. So let's disclose it. Oh, and maybe waterproofing the basement is only $5,000 and we give them a credit for it. Like it's probably not as big a deal as they think. And it is almost certainly in their interest to over disclose instead of under disclose. Okay, I'm a broker. I have to say the words over disclose instead of under disclose. Okay. Are there questions about latent defects?
Hi, how you doing? I have a question.
Yes.
What would you say is a reasonable like price range of a latent defect? Does that matter? Or like as far as like if it's a low cost to cover it?
No, price does not have anything to do with a latent defect. If it is hidden and could potentially be a threat to health or safety, it's a latent defect. If it's a $50 fix, you tell the seller to fix it before you put it on the market, and then you don't have to disclose it, right? So that was the other point I was going to bring up, if there weren't any questions, was if you have a leaky faucet and then you fix it, it's not a latent defect anymore, okay? Now, if you do a crappy job or you kind of wrap tape around it and pretend you fixed it, that's maybe a different situation, but latent defects are by their nature ongoing problems. And the definition of a latent defect is not set by any monetary standard. Thank you for the question.
Thank you.
Yep. Okay. If you're a buyer, it's a little bit easier to get through this agreement. There's not quite as much stuff you need to go through. But the buyer side, and we already got into this a little bit, this is the agreement that was most impacted, I would say, by the national lawsuit. Okay. So a lot of this is gonna look pretty similar to what this listing agent, what the listing agreement looks like, so I'm gonna breeze through some of this. Type of property, I never really care what people put down here, maybe it's a row home in Baltimore, maybe it's investment property, sometimes you just write real estate, that's fine too. This is really just a discussion moment, like, hey, what are you looking for, guys? Again, it must have a beginning and end date. It shall not be longer than 1 year in duration, including extensions. And you need to have a fixed way to get out of the contracts. The parties aren't wedded to each other indefinitely. So again, I put something like unilateral termination by either party with 3 days written notice unless under contract. Okay. I think they actually bumped up the broker compensation paragraph, so it's higher in the page, because this is kind of important to your clients potentially. So again, this looks exactly the same, but this is a little bit more. It's going to potentially impact the pocketbooks in a really direct way for the buyer in ways that they're not comfortable, that they weren't previously understanding. So this is where we used to do, and I was essentially trained when I started in real estate to do some kind of shady stuff. Okay, and I don't really mean like deliberatively fraudulent, but definitely stuff that sort of raised questions from outside observers. So we used to put things like, oh, whatever the seller will pay, like I'm free essentially, like that's not a way to run a business. Like that's inherently kind of a weird concept that obviously rubbed people the wrong way. So much so that outsiders and a judge ultimately, and a jury rather, ultimately said like, that only makes sense if there's kind of like a conspiracy that says you're going to get paid X amount, right? So that's kind of how we got ourselves into trouble. Okay. So we're not doing that anymore. But that's fine, because everybody in this room and everybody on Zoom is a professional that provides a valuable service, and we charge a fee for that service. Okay? The fee needs to be easily calculable, set at the outset of the relationship, and it doesn't change like, oh, if we see this house, I get paid X, but if we see this house, I only get paid X, so maybe I won't show this house, right? You have a fee that you set forward. The fee's in exactly the same way as before. It can be a percentage, it can be a flat fee, or it could be some combination. So let's say this person charges 3% plus a $500 fee. That's their fee. Now don't brush over this, guys. It says straight up, if your buyer signs this, compensation to be paid by buyer to broker. The buyer is responsible for this money if they sign this document. Okay? Do not skip over this paragraph. They need to understand what this means. There's a saying, do not screw me over paragraph. But what it does say, compensation may be offered from the listing broker. Oh, wouldn't that be great? Buyer shall attempt to secure an agreement for the amount of offered compensation from the listing broker prior to submitting an offer. The amount of compensation received shall be credited against whatever the compensation you set forward. And here's the fun part. Buyer is prohibited from receiving compensation from any source exceeding the compensation amount in paragraph 5A. So if you were charging 3% plus a $500 fee, and you don't want your buyer to pay for it, you need to ask, and it needs to be in writing, that either the seller or the listing broker is going to make that payment on your behalf. So there's more paperwork involved to get paid. This used to be pretty straightforward. It was still confusing, But so the benefit of the old system was that the contractual compensation piece was already baked in. On the MLS, it said, you get 3%. That is an offer by contract. If you bring a buyer, that is an acceptance of that offer, boom, bam, broker gets paid. The MLS doesn't talk about compensation anymore. It's not on there. So there's no offer that can be accepted. So the only way you get paid is if you have a piece of paper signed by all the parties that says the seller is paying X and the seller is paying Y. Okay, that's how you get the seller to pay for stuff. So when I have this conversation with my buyers, I say, look, this is my fee. I'm a professional. You go to an accountant, you go to a lawyer, they charge a fee for services. I'm going to fight as hard as possible to get the seller to pay for that. And we're going to know in advance because the offer is going to include that the seller pays for it. Okay? In most cases, I'm really good at my job. I'm a good negotiator. I'm gonna do what I can to get this paid for them, from them. But there's also a chance that the seller says, no. The seller might not be interested in paying for my fee. In which case, that house basically became a little bit more expensive, right? The buyer needs to bring more money to the table. So we'll have a hard conversation, like this house might not be the house for you anymore. But there's never going to be a surprise, right? Because we're going to have that conversation. Everything's going to be in writing. Either the seller's paying for it or they're not. Is this still the house for you? Because look, this is this is a lot of money if the buyer has to pay for it. You're talking closing costs, down payment, and a realtor fee in cash that they have. This isn't stuff that they can finance. How many buyers have we worked with that are scraping nickels together to get to the closing table? They don't have an extra $6,000 or $10,000 to pay their buyer agent. So they just can't buy that house anymore. And that sucks. But this is the game that we're playing. We are charging a fee. They're responsible for that fee, but we're going to do everything we can to get the seller paid for it. Okay, question one.
What would you tell a potential buyer who says, same scenario, but they say, can we in the contract say that we want a credit of say 3%? And you get paid for that 3% credit. Did that work?
Okay. The question was, can you ask for a credit instead of the seller explicitly paying the buyer agent? Can the seller give the buyer a credit and then the buyer can do their own thing? Okay. This is a really complicated question. I believe the answer is essentially yes. Your buyer broker fee is a closing cost. It is. If you just want to ask the seller to help with closing costs, you can do whatever you want with that money. That's my position. There are two problems with that. One is, depending on your loan product, you're capped at the amount of assistance from the seller that you can get, right? And if 3% is going to your buyer agent, that's not a lot of room if you needed help with repairs and stuff. So the state of Maryland, the way they manipulated the forms, it's kind of disfavored to do it that way because it can kind of screw up the loan product. Also, I can tell you that there are sellers that get pissed. They'll see that like, oh, but I didn't agree to that, so now you're working around. Personally, I don't think the seller has much of a leg to stand on when they're trying to mandate what you do with your closing cost assistance. But it's worth noting that it could become kind of an explosive situation. I have seen it where sellers get, no, I said nothing to the agent. I don't know if an agent was mean to them one time and they don't have any interest in money going to that person. And if they get to the closing table and they see that money is somehow going, they could get a little miffed about it. But legally, it's a closing cost. Like you get closing cost assistance and everybody's agreed to it. I think it's technically fine, but you need to be super careful. A, that you're not blowing up your loan product. And we need to understand that that could create some tension. And tension has ways to impact your deal in ways that are uncomfortable. So hopefully that's helpful.
Thanks.
Okay. Good question. All right, so I think we've gone over. The money stuff. Comply with fair housing. And most of this is just like general heads up things. Make sure that you sort of understand it, but I'm not going to go through all these paragraphs. Yeah, just mostly just like heads up for the buyer. Okay. That's not too bad, you guys. We can talk a little bit about dual agency real quick and then I get to your question. A lot of times it's best practice to have your buyer fill out the consent to dual agency. So I'm the broker for Keller Williams Legacy. If one of my agents has a listing and one of my agents has a buyer for that listing, I want to encourage the buyers and sellers to sort of allow those parties to play nice together. To the extent that there is a conflict, it is with broker Doug. But there's lots of protections in place that, hey, the seller and the buyer agents shall not share with broker Doug information that's problematic or shall not share information with each other that's problematic. All right, question from the back.
My question is, what if you have a buyer and you're going to a new construction community? Now, we have the buyer brokerage, let's say we have the buyer brokerage agreement already in place. Let's say we're just doing the standard, we'll do 2.5%.
Okay.
Commission.
I won't say it's standard, but you can charge 2.5.
Okay, yeah.
Yeah, thank you.
So let's say we go there and they say, hey, if you can get your buyer under contract for lot 25, we'll throw you an extra $2,000. So.
In addition to 2.5%?
Yes.
Too bad, so sad. You can't take it.
So basically, yeah.
So
Okay.
the concept of
All right.
these bonuses and incentives
Yeah.
definitely get a little fuzzy, right? Now, oftentimes the builders especially are the ones that are screwing realtors anyway. So maybe they were only offering 2%, then maybe the bonus is fine, right? Some people even are putting, maybe they'll put 3% down in their buyer agency agreement
Okay.
because they don't want to be capped later if they have a generous
Okay.
seller.
So that was my, okay.
So
We could put more.
you can put more, and the state of Maryland has no problem with you reducing your commission.
Okay.
Everybody's cool with buyer agents being paid less, like that's never a problem. But don't then, oh, the seller's offering a bonus, let's increase this to 3% instead of 2%.
Okay.
That's where you get sued. That's
Okay.
where your broker gets mad. But yes, it becomes a little bit sticky there. And I literally have this, I have a new construction client where I charged 2.5%. And they were giving me 3% on the seller side. I'm like flabbergasted that they offered 3%. And I'm like, all right, you like, best go collect $200, Mr. Buyer. I'm gonna credit you this extra 0.5%. And they were very happy with that. So maybe that gave me some brownie points, but I would have loved to get that extra money too. Yeah. Okay. Those are the brokerage agreements. That's how you get paid. How am I doing on time? Not great. Okay.
If I understand very well,
Thank you.
if I understand very well, you charge 2.5 and then the seller is giving 3. If you cannot use the 0.5, you can credit the buyer.
I say yes. If it's money that the seller is willing to give to the title company for distribution, I say you credit that to the buyer. And then the buyer agent is not being paid. Now,
That's 0.5.
My position is absolutely, as long as the agent is not being paid more than they're supposed to, they're complying with the law. Okay? Now again, it could be a situation where the seller gets wind of it and they get pissed, but sorry, like you said that they could have this money. Yeah, so that's my position. Okay, real quick with your. Every time you have a buyer agency agreement or a listing agreement. Bright are the ones that get to actually enforce the lawsuit settlement terms, okay? One of the ways that they do this is that for every real estate client, buyer or seller, if you have a brokerage agreement, Bright says you need to have one of these Bright MLS disclosure forms. So I literally Google Bright MLS disclosure form, or it should be in your DocuSign or .loop if you have access to the Bright MLS library. There, I think if I can pull it up. Zoom thing out of the way. Okay, this just changed, you guys. Because it sucked before and now it sucks a little bit less. It used to be one document, now it is 2 documents. One is for sellers and landlords. It's this nice red one. If you're working with buyers and tenants, you have this nice blue one. Okay. If you have a buyer agency agreement, every one of those agreements should have this attached to it. You get them signed simultaneously. And all the buyer side does is say, hey, how does Bright work? Oh, hey, by the way, commissions are negotiable, please initial here. Easy document. Okay. If you're working with a seller, your listing agreement should have this red document attached to it, signed at the same time. The first half is exactly like the buyer side. This is what Bright does. Commissions are negotiable, please initial here, Mr. Seller. And then this also gives us instructions on how to market the property. This will mostly mimic what you already discussed in your listing agreement, where they check and say, I consent to go on Zillow, all that fun stuff. This will just match what's on your listing agreement, essentially. In most instances, you are checking box 2A. Please market my property. I want it on Zillow. I want everybody to know about it. Please put my address out there. 2A, yes. 2B and 2D are a lot more nuanced if they want office exclusive, if they want it to be partially marketed on the internet. 2C is your other common one if they're taking advantage of coming soon. This is where you would actually set forth ready for showing beginning on some certain date. That's where you'd put it there. And then either yes or no, I want it to also be marketed on the internet and Zillow. So really you care about 2A or 2C in almost every instance, but you need to have this completed alongside your brokerage agreement. If you don't have access to it in your personal brokerage libraries, Google Bright disclosure forms, this first thing right here. Seller and buyer disclosure forms. Okay. Probably should be able to change this. This was this looking. All right. Maybe we should talk about a real estate contract of sale if you're here for a contract. Okay. This is really the only contract that you should use, guys. If you're a member of GCAR, they have their own only contract. They have their own contract that they can use. If somebody submits a different type of contract, if it's an investor that has their own thing, they can use that contract. A buyer and a seller can sign whatever contract they want, but I can't talk to you about it. Realtors are form filler outers. We can talk about the MAR forms because we know that they have been vetted by real estate attorneys in the state of Maryland. Every time there's a new piece of legislation or a new local regulation, It is imported into this form. This is the only form that we're essentially allowed to talk about. Okay, and even that, like, I'm an attorney and I still avoid giving legal advice related to real estate. Don't mess with it if you don't have to. Yeah, great question.
What if a listing agent says, you know, where I'm going with this?
Okay.
You can only use Charles County, whatever the form, G-car form instead of NAR.
Yeah, so the question was, what if a seller requires the use of a form you're not familiar with or don't have access to, or is their own special form? It comes down to our competency essentially. So it's really a conversation that we have with our buyers to say, all right, Ms. Buyer, if you want to fill out this contract yourself and send it to the seller and figure it out amongst yourselves, that's fine. But I can't really talk to you about it because I don't know. It's not the level of service that we want to provide, right? We want to be helpful, but I also don't want you to be convicted for the unauthorized practice of law, right? Like we do need to be very careful when we're working with forms. Builders and developers will do their own thing, right? Like if you've done new construction, they will send you a form you've never seen before. You will kind of do your best to look it over for any red flags, but you're ultimately saying like, all right, here you go, buyer, if you want this house, this is apparently what you need to sign, and they need to make an informed decision. And also, I love the words, go talk to a lawyer. When that happens, I am putting it in writing. I recommend you seek qualified legal counsel. Send. That's gonna cover you and give you a lot of protection, right? It's like, always say that if there's something you have a question about. Okay. You're making an offer. We talked about be simple, we talked about ground rent, so we're gonna know how to say that. The payment terms, you guys familiar with the earnest money deposit? Okay, that's good faith money that you're kind of putting up there that says, hey, if I breach this contract, Mr. Seller, I'm risking losing this money. So this good faith funds that you're gonna put up. These are typically gonna be held one of two places, either the buyer's brokerage or the buyer's preferred title company. Okay, if it is held, please read this bold. If a deposit is held by not a brokerage, so if it's held by a title company, then there's an extra agreement that you need. So there's this escrow agreement that I'm going to talk about in a minute. You don't need that if it's held by a brokerage. Brokerage is governed by the Maryland Real Estate Brokers Act, which says exactly how they're allowed to treat it. Title companies are bound by that act, so they need this extra piece of paper that says, this is how we release it, this is how we talk about it. You have 7 days to get that to your clients, or to get that to the escrow holder. So it'll say, by some certain deadline, do not put more than 7 days, because if it's more than 7 days, they get in trouble. And it's pretty much always going to be held in a non-interest bearing account. I've never seen one held in an interest bearing account. So I wouldn't mess with that. Okay. You're gonna pick a settlement date and you're gonna go through all these and check the right boxes, right? This is your memory jogging checklist as well. So, oh crap, there is an HOA. I need to make sure I ask for that or request that. Or, oh, I do remember seeing solar panels. Let's make sure we ask for that. So there's a lot of addenda here. Some of them are common, some of them I've never seen used before. But just make sure that you have a full understanding of what these documents do, so that especially if your seller or if your buyer is requesting something novel in terms of post-settlement occupancy, or it's contingent on the sale of their home, or they want to be able to get out of it for XYZ, anything that resembles a contingency, we need to make sure that we're protecting using the standard forms.
I have a quick question. Is there a reason why the general addendum to contract of sale isn't listed as one of the addenda?
Because it is not an MAR form is the answer. So it is our policy in this brokerage that is a required document, and that is through GDBR's site is where we usually get it, and not through MAR's site. So different brokerages will have requirements for different addenda. It is so, but also I think that means that it's not legally required. Like the contract is still enforceable, even if you don't have this. But I interpret that document as just a great sort of CYA for realtors. So, you know, it is broadly understood that it's a required document, but it has not been adopted by MAR, which is why it's not on this checklist.
Thank you.
Yeah. But yeah, you would check other and say general addenda or whatever else. There are different addenda that your brokerage might require.
Question for you.
Yeah.
Isn't all the language in the general addenda included in the contract of sale?
I think there are a couple of differences. Like I don't feel that strongly about the general addendum personally to really speak to it, and it's just a consult with your broker if they require it. Whether or not they should require it is a great question. But yeah, it's just whatever your brokerage and compliance department is going to require.
Thank you.
Yeah, thanks.
Hey Doug, Beatrice.
Yep.
So in this body of the contract pages, it states that this is an as-is property. Do we need to also add that addenda, as is?
No, great question, and let me spend a few minutes talking about that.
Okay.
Let me scroll down and I'll get to where that becomes important. All right. So some of this is really basic stuff, guys. At the top was the time is of the essence paragraph. That means deadlines matter. If you miss it, it's a breach. If it's a breach, the other side can get out of the contract. Deadlines matter. Computation of days. As much as people would like weekends to not count and holidays to not count and everything else, a day is a day is a day. The days start the day after an agreement is executed. So if you have 5 days and you execute on the first, it is 5 days starting on the second of that month. For financing, you're going to make sure that you check any of these boxes. If you want it to be contingent on financing, which you probably do, there's a different financing addendum depending on your loan product. We'll spend a few minutes going into that. Generally speaking, you're going to want a quick turnaround on how quickly you apply. You don't want to dilly-dally here. If you are under contract, you better damn well apply for financing within a couple days. So I usually put, 1 or 2 days here. And then I want a loan commitment like at least a week before closing, and generally within, 21 days is kind of a common number here, but if it's a more expedited settlement, then you may need it before that. So just talk with your lender about what is realistic for your financing commitment. Buyer responsibility becomes important. Make sure that you do not lie to your lender. Make sure that you actually fill out the documents and check the boxes when they tell you to fill out documents and check boxes and provide things. If you don't do that and it causes a delay, the seller can go after you. Let me find. Okay. Beatrice, your question was, is this an as-is contract? One of the bigger changes, I think 2 years ago in the contract, was that we've tried to make this essentially an as-is contract, except, okay, shall deliver the property vacant, clear of trash and debris, room clean, and in substantially the same condition as existed at the date of contract acceptance. So it's as is, but you still got to do this stuff. As is doesn't mean you can have a tenant in there. As is doesn't mean you can have all your crap in there. So this paragraph still sets forward the obligations that the seller has to actually get it up to a certain standard. Now, if you want to waive paragraph 25, there is, that's called the additional as-is provisions addendum, but that's a pretty crazy addendum. It basically says like, no, this is for real as is. it can be a hoarder house, there can be squatters in there, like, so there are situations where you would do that, but that's in a really unique situation. So a conventional normal property transfer is still gonna need to be vacant, mostly clean, removed of debris. But if the sellers want an inspection, or if they want, any of these other things, they need to make sure that they opt into those particular protections. Does that make sense?
Yes, definitely.
Okay. All right,
I have a question.
yes,
For the financing addendum for hard money lender, what do we put?
so there's not necessarily going to be. So the question was, there a financing addendum for a hard money lender? So what you would do. So there's still. So you would say the purchase is contingent upon the buyer obtaining a written commitment for a loan secured as follows. So you would put in here hard money lender in paragraph 19. So it would still make it contingent upon those funds being available. Okay. All right. If you want an inspection.
Sorry, going back to what you just said about the hard money lender, the buyer can't say that's cash, correct? They have to specifically state that was hard money. Because I've seen in the past where hard money was stated as cash offer.
Okay, so those are, yeah, so they are two different things. Basically, if somebody's saying it's cash, I want them to check this box right here. No financing contingency. That's saying you have the cash. Nobody can deny you anything. So you don't need a financing contingency. Okay? Otherwise, if they're getting a financing contingency, that means there's a loan product somewhere that they're either going to qualify for or not. So be really specific about, what they're providing and ask those questions, because you're right, that would be confusing if someone says that it's cash, but if they secretly check one of these boxes that indicates a financing contingency, then there is a financing contingency. Okay. I love questions. I need to stop people from asking questions for a little bit because I want to get through a little bit more. Okay, I'm so grateful for this conversation. And I love being a broker that gets to answer these questions. Okay. If you want an inspection, you need to check yes, and you need to provide the addendum, because otherwise it's an as-is contract, right? You need to actually do both of those things. Check yes, I want one, but it doesn't say yes, I want I want an inspection. It says inspection addendum attached. We've tried to sort of dummy proof this for all agents. Okay, they talk about the deferred water and sewer, which we've already talked about in the listing agreement. You have to disclose if you have well or septic, you'll have to build that all in. Okay, these couple on agricultural and forest conservation. I never know as a buyer if these things exist, and if they're not disclosed, there is actually a requirement for the seller to disclose if these things are in place. I will usually put, we don't have to, seller if any. For both these, seller if any. Because what I don't want you to do is leave it blank and then somehow this thing pops up and then it's really confused. I've never seen sellers kind of balk at that particular thing. Buyer has to initial that they understand about lead paint. Right, this stuff is not that exciting. Seller has to actually be able to convey title. There is kind of a fun provision in here. Has anybody been exposed to or seen this like magical 14-day extension that could pop up if there's a title issue? So really unusual, guys, but keep it in the back of your mind that if there is a last second title thing that is delaying or threatening to blow up a deal, the seller can kind of like get an automatic extension if they're working on this stuff. So if the seller wants to fix it, it'll automatically be extended. I still want to get a formal extension that everybody signs off on, but just keep that in mind if there is a last minute title issue that pops up. Okay, transfer charges. I find this language very confusing. Most people are just gonna leave this blank, right? So this literally says taxes will be divided equally unless otherwise stated here. If you don't want to change it, then don't change it. Just leave that blank. Don't type in taxes split equally because it's already split equally. Just leave this blank unless you want to say seller pay all taxes, buyer pay all taxes, that sort of thing. I'm not taking questions right now, but I love that there's a question.
That's no question.
Okay, just saying what's up. Appreciate what you saying. Okay. We already talked about if they are a non-Maryland seller or a national, there may be tax implications. Yeah, it seems like a bunch of lawyers got involved with this document, added a whole bunch of stuff that protects who knows who. Okay. There is a mandatory mediation provision. I just had to talk to somebody about this the other day where buyer wants to sue the seller. Great, go for it. You have to mediate it first. It's like $450 per party to mediate. You go through the mediation step. If it's not resolved there, go to town, go to court, hire a lawyer. If you do go to town, go to court, hire a lawyer, and you win, you can get your attorney's fees paid for. So I do like to throw that if you're going to make a real threat, say, I know I'm only suing you for $5,000, but it can quickly become $15,000 if you make me really do this. So that's a little bit of extra weight. The date of contract acceptance is super, super important. There's guidance here. Basically, the last person that signs the last thing, put the date there, please, and also send the contract back. If you sign it at 11:50 p.m., but don't send it back until the next morning, it's very confusing as to when the deadlines need to start. And it really, really matters, guys, if this is what's triggering inspections and financing obligations and all this stuff. Come to an agreement on day one, and if there's a dispute about that date, figure it out. Don't let it live. Okay. Please fill this out as well as you can. This is technically sort of for information purposes only, this page 11, but it is immensely helpful for all parties, especially maybe your broker, if something becomes disputed. I only spent a minute talking about this document that isn't going to apply that often, but it summarizes a really important one. A lot of my job is fighting about EMD, and I hate it. But I am now very intimately familiar with the rules for EMD. This is what y'all are going to fight about when things go south, right? If somebody's holding $7,000 and both parties want that $7,000. If I'm holding it as the broker, I don't get to just dish out this money as I please, right? I am very rigidly controlled on how I can distribute the funds, and so is any title company that's holding it. It is extremely tight, okay? But this document spells out something that I don't think everybody is familiar with that is potentially helpful for your buyers. So the law was updated last year, providing an expedited method to release earnest money to your buyer if they terminate due to certain contingencies. Okay, so if you have a buyer that gets out due to an inspection contingency, that gets out due to HOA, any of the contingencies that are listed, basically they're deadline dependent, so it's really cut and dry. Like I had 7 days to terminate due to the inspection contingency, I terminated on day 6, give me my money. And the escrow holder has to give that back to you. Okay, that didn't used to be the case 18 months ago. In most cases, right, the seller and the buyer need to agree, and there's a piece of paper that says, dear escrow holder, 5,000 to seller, 5,000 to buyer, everybody signs. But if you Here, let me scroll down, because this is the document you're gonna wanna look at. It goes all the way down. If buyer terminates pursuant to a contingency. As defined by section 10803A2. Doug, why did you highlight section 10803A2? Because it's not quite every contingency. Specifically, it does not include the financing contingency. That's a big one. That's like one of the 3 reasons real estate deals fall apart, okay? So if something falls apart due to financing, you have to go through the normal mechanism where you're basically just fighting it. Okay? But most of the other contingencies that are deadline based, as long as you strictly abide by those deadlines, your buyer terminates through the appropriate mechanism. You just send, so what is it? So you submit this request to all parties saying, hey, give me the money. Unless the seller delivers a notarized written request for mediation, then they can't oppose it. So that's like, all right. Because let's be honest, there are sellers that were just kind of a-holes about it, that were just pissed that the property didn't sell, and they're just gonna hold on to this, the EMD out of spite. Like, I see it constantly, and for the and forever, there was nothing you could really do. Now it's like, no, Mr. Seller, if you really think you're entitled to this money, go file for mediation. Like, pay the $450 and go after it if you really think you're entitled to it. And if they do all that and get it notarized and send it to the escrow holder, then they'll hold on to it and sort of allow the fight to go through. But this expedited EMD release is so important, and it's new and not everybody knows about it. So, you know, if there's ever a fight and it's kind of a standard thing, you may be able to get the money back a little bit quicker. The PIN change, or the property inspections addendum, changed a couple of years ago to make it a little bit more streamlined. So basically, you're going to have one deadline. There used to be like 6 days for structural mechanical, 7 days for chimney, 10 days for WDI. Like, it's one deadline. If you want it really, really appealing to the seller, some people will do like a 3 or 4 day deadline. 7 days is kind of in the middle. Sometimes if it takes a while, like maybe 13, 14 days. You're going to have a deadline. This deadline, guys, is not the deadline for the inspection to be performed. This is the inspection needs to be performed. You need to have a copy of the inspection report. You talk to your client about the inspection report. You put together a list of repairs and you send it to the seller.
In 3 days.
All within that, whatever you put there. If you put 3, that's what you're doing. So you probably shouldn't put 3. You should probably put 7 and have 5 inspectors on speed dial that can get there quick. Right? Like, that's going to be the key. It's having these resources available. So some people will check all of these, saying I want every single inspection. Some people will only, I sold a house that they're like, no, we pretty much saw everything. Let's just do the wood destroying insect inspection because I couldn't get into the attic. Like, so that's a way you can do it. Or you can just check, this is what I usually do. I'll say, I'm going to do a structural mechanical, and I'm going to type in something here that says, other inspection as recommended by structural and mechanical inspector. Okay, this is the kind of catch-all cheat code. If you get in the inspector and he says, there's issues of termites here, you should really have that looked at. That would trigger, he said he actually now triggered this extra thing that I have a right to go send in a termite inspector. Or shoots the flashlight up the chimney, this looks a little rough, maybe have that looked at. You can send out a chimney inspector. But again, it's all within that. If you put 7 days, that's for all your inspections, not just the first one if you're trying to lump in a bunch. So really, time is of the essence here. Now, some sellers aren't going to love this language because it really is kind of like, do whatever you want, but I think it's an important thing if the general inspector find something with the roof, but then they need a roof specialist, or I do think it's valuable. And sellers, it's common enough where most sellers are not kind of pitching a fit about it. Okay. So you got your inspection performed, you have the inspection report in hand. There are two paths, path A and path B. Path A is the right to terminate. You can just say, I don't like the look of this house anymore, I'm out. This is a new thing as of a couple of years ago where you don't even have to request a repair, you just say, I'm out. Send a unilateral notice of termination, inspection, don't like it anymore. As long as it's within that deadline, you can just peace out. Okay? Or you negotiate repairs. That's path B. But once you go down path B, path A is gone. You can't just peace out anymore. You need to kind of go through the full negotiation. Okay? With the right to terminate, you don't even send them the inspection report. You paid for it, it's your property. Just like, I don't like this house anymore. And in fact, a lot of sellers say, no, thank you, I don't want to receive the inspection report. I don't want to have to dispose more stuff. So you can just get at it, okay? But if you're negotiating, you're saying, I need the roof patched pursuant to paragraph 3F, and you send them the report. Okay, this is all within the same deadline. You send a repair's request through the property inspections notice, which is also on the NAR website. And you're going to attach the report alongside it. And please be super, super specific with your request. That's the other way I kind of see things going south. Don't just write like roof, okay? Or like patched roof by licensed contractor per recommendation 3F. Like be really, really specific. So the seller isn't interpreting what you want. And if you do need to try to terminate this contract because they failed to do it, be like, the seller will be like, I did roof. I wasn't sure what you wanted, so I did different roof. Be really specific. And really pay attention to these timeframes. I'm not going to go through everything, but this will guide. It's basically a ping pong ball that goes back and forth. You send the repair request. They have 5 days to send it back to you saying, okay, I'm going to do 1 through 3, but not 5 through 7. You can kind of go back and forth a couple times. Importantly, if you're in the back and forth, someone sends it back, but there's not a fourth that comes back. You may have bound yourself to whatever that last offer was. So don't just ignore stuff. If you have 2 days to respond to something, you better respond or you better terminate. Otherwise, by contract, you may be agreeing to whatever the seller just sent you. Okay, so just read this really, really carefully. And this is where we can do harm to our clients by not really explaining what is going on or just missing deadlines. Okay, really, really important stuff. So this is the back and forth that I talked about. So this basically says, hey, if you terminate, you have to then just go to the release of deposit paragraph. The release of deposit paragraph is just like, fight over it, unless it's one of these itemized contingencies of which inspections are included. So as long as you comply by these deadlines and you get out of the contract, you should be able to automatically get your EMD back. You have a right to reinspect. This may be in addition to the walkthrough, guys. A lot of people use the walkthrough as the reinspection, but you do actually get both of those opportunities. Okay. Any quick questions about inspections? I know I said no questions, but inspections are medium important.
I have a question. What do you think about the sewer line inspection? Do you think you have to specify that, or does that fall under structural and mechanical? There's a couple different opinions on that.
So I don't know that there's a benefit in kind of surprising the seller with that, especially because you usually have to like unscrew something that might be hard to unscrew, or I've had situations where the waste outlet is like soldered shut or rusted shut, and they've had to like remove a toilet to shoot the waste inspection down. So I would say absolutely that should be separately itemized. Because it's something that the seller, it's invasive enough where the sellers might be frustrated. And I'm kind of like go along to get along, like whether or not you could legally get away with it, like surprising of the other party and just like rubbing people the wrong way does as much damage to deals as does like actual breaches. So that's my position is generally, you know, give them as much warning as possible. But yeah, I've always seen those separately itemized.
Okay, thanks.
Yeah, I had one other question.
Yeah.
You're going back to where other inspections, you have all your inspections, and at the bottom it says if they request any other inspections. Now there's a time limit. Let's say you got 7 days to do an inspection, or 10 days to do an inspection.
Yeah.
But then it says other inspections may be required to do repair or do inspections. Do they have to do that within that 7 day, or is that automatically extended a period of time?
Nope, your deadline is your deadline. If you need more time, you better get that deadline extended. But your deadline is your deadline. There's no automatic extension, regardless of what you write here. Now, I have seen it, like, parties are working through it. Like, let's do a change of terms addendum where you could say, look, parties agree to extend the deadline by 4 days because we really need to get a roofing contractor out there to get a quote for something. So there absolutely is room for parties to negotiate. But do not let that deadline pass until you get any kind of thing like that in writing.
Right. So what happens if you got 7 days to do an inspection and they say other inspections is required by the inspector? If you have other things to be done, it's got to be done within 7 days, because the seller can say, hey, no, I'm not doing any more inspections. The 7 day ends and that's it.
Absolutely. Yeah. The deadline is the deadline is the deadline. And I'm willing to put, you know, other inspections as recommended, but that better happen real fast. And that's like, okay, well, let's send out a bug guy. Let's send out a chimney inspector and just call everybody that can get there the next day, sort of thing. But it could be like, oh, they flagged a structural engineer needs to come out and look at that, and they're not available for 10 days. That's when you have the really candid conversation, like, look, we really want to do this, but we absolutely need to have this, you know, engineer sign off on it. Please agree to extend this deadline, or we just need to terminate this contract within that deadline.
Right. And that, see, I think a lot of realtors don't realize that the fact that, you know, that deadline is deadline, even though you say other inspections, but you got to have it, you got to make sure you give yourself some time. Otherwise,
time is of the essence. There was one deadline, and that was the big change, right? So you used to be able to put a longer deadline for different inspections. It was super confusing. Right now, you are picking one number of days and you are bound by that no matter what you do. So great clarification. Thank you.
Hey, Doug.
Yeah.
So if the seller agrees to a home inspection or any inspections, does that obligate the sellers to perform any request by the buyers?
No, this is literally saying I, the buyer, with my own money, am securing the right to bring out these inspectors, and the seller has to sort of accommodate the inspector getting in there, but they're not pre-negotiating to provide any credits or perform any repairs or anything like that. That's all well after.
Would there need to be an email sent to the buyer's agent to say, you know, we allowed you to do your inspections, however, the seller is not making any repairs or giving any concessions?
Yeah, that sort of arrangement can be created. But if the seller signs a contract and the contract has an inspection contingency, and that inspection contingency allows for negotiation of repairs, don't be surprised when a buyer performs an inspection and requests repairs. Like, you need to have that agreement extremely well understood. Or just be completely comfortable saying, ask for whatever you want. I'm not doing crap because I told you it was as is. And as long as you're really candid and honest about it, like, this is an estate sale. We don't have any money. Like, do your inspections, but I'm not paying for anything. You can absolutely make that clear. And if they ask for something, just say no. Or maybe you say, okay, I'll fix it, whatever, just to like figure it out. 'Cause
Understood. Just
unfortunately, yeah.
understood. Just didn't want that to be, it is an obligation just because the sellers agreed to the
Absolutely.
inspection.
Yeah.
Doug, I have a
Exactly.
question. So after that inspection is done and we found latent defects, I just want you to speak on what is the listing agent's responsibility as they put that property back on the market, please?
Are you saying, okay, so you're saying, yeah, so if you go through this negotiation process and your seller receives an inspection report, that's gonna have a whole bunch of crap in there that the seller didn't know and probably didn't want to know, but they know it, right? So my position, it's pretty clear that on subsequent listings, if there are defects that are hidden from a buyer walking through and could pose health and safety defects, they absolutely need to update their disclosures to report those latent defects or fix them, right? Like, they now have, the question is about actual knowledge. Do you have actual knowledge when you're putting your property in the market of these latent defects? If you do, you have to disclose it, right? Do sellers break the law all the time and pretend they didn't see certain things and, go forth and just say no latent defects on the subsequent listing? Yep, I see that all the time. And those people are absolutely opening themselves up to gigantic amounts of liability.
Thank you.
All right.
But he's asking about the agent. The agent knows it, the agent is obligated to disclose.
So the seller,
He says if they put the property back on the market with that agent, is what I understood him to ask.
so sure, so usually the listing agent and the seller will have both read that report, right? So they're both gonna have actual knowledge of a whole bunch of stuff that probably needs to be disclosed. So there's two different obligations. There's the listing agent's obligation threshold, which is actually quite low. If they have any knowledge of a material defect that could impact the price of the home, they have to disclose it. Okay, so the conversation that I have with the seller is, Mr. Seller, you disclose this or I will. Like, I'm not losing my license for this. And the path of least resistance, if the seller listens to you, they're just going to update the disclosure disclaimer appropriately and put down those items. If the seller refuses, then yes, the listing agent hypothetically needs to disclose that, or quit or get fired, or it sets up this really high stakes drama. But yeah, no fun.
Now, what if the buyer says they found lead, they are backing out, they don't give you the report? What do you do as this?
Okay, so the question was, if the buyer just says out loud, we found lead, we don't want the house anymore, but they didn't provide the report. Those sorts of things are gonna be so case specific, and like, what triggers a duty to investigate? And honestly, like, did the buyer actually find lead, or did the inspection just say, hey, this type of tile might have lead, like, seek evaluation? So it's like, it's super subjective. It's questions like that are gonna be really on a case-by-case basis.
It could be a way also just to get out of it.
It could be them just, right, saying stuff because they're pissed about something else. So I don't know that I can answer that in a concrete way, but it's a really good question and something you're gonna have to talk to a broker as it comes up. Okay, That's the inspections. Easy peasy. I want to highlight one thing on the financing addendum. Again, if you are using a loan contingency of any kind, you're going to want to include a financing addendum. If it's an FHA, use the FHA addendum. If it's VA, use the VA addendum. If it's a conventional product, use the conventional financing addendum. Based on the pre-approval letter, essentially, you're going to figure out how to fill out all this stuff. Loan program, in this case, I just write conventional. If there's something more nuanced, it's technically still called conventional that the lender provides, you can write that down. This just changed, you guys. If you are pursuing some additional financing program, i.e. grants, you need to put that here. The seller ought not be surprised about a grant popping up at the 11th hour that requires an additional inspection or an additional appraisal or an extra level of scrutiny that causes a delay and can harm the seller. Now, I'm not saying this is right, wrong, or indifferent, but this kind of opens up a whole new layer where if the buyer fails to disclose this and it sort of harms the seller in even an inconsequential way, arguably the seller can now say, like, that's a breach of the material term of this contract and they can get out of the deal. So just be really careful. The way that you fill this out, make sure that it's accurate. And this also, guys, there are two pieces here that you're going to need to pay attention to. This gives you an opportunity to pre-negotiate lender required repairs. This is when the lender sends an appraiser and the appraiser says, yeah, this is worth $350, but only if we install handrails. And that's going to cost $1,000. You could, as the buyer, say, all right, I'm going to put in $1,000 there. Of course, not letting me type. And if the seller agrees to that, they've already agreed. If the seller repairs are at or less than $1,000, the seller's just going to pay for it. If you want a really, really compelling offer, if it's a multi-offer situation, maybe you put zero because you don't want to obligate the seller to pay anything. So figure that out. It's a little bit of a kind of a loose negotiation tool. And this is also your appraisal contingency, guys. This is built into the financing addenda, which is one of the reasons you really, really need this addendum in place. The appraisal, guys, is what the bank says the property is worth. There could be a multi-offer situation. 10 different offers all say it's worth 500. If the bank says it's worth 450, they are only lending up to 450. Right? The bank isn't interested in financing over what they think it's worth. Okay, so if you're capped at 450, you would then go back to the seller and say, look, I know we agreed on 500. I don't get that loan anymore because it didn't appraise. I only have access to 450. Mr. Seller, would you please reduce the purchase price down to 450? And you kind of hope that they do, but they don't have to. They could say, look, I think it's worth 500. I don't care what your lender has to say. You know, we'll just get out of the deal if you really need me to reduce that. Sometimes there's a negotiation. Okay, reduce the property by 25. I'll get a gift from my aunt to bring an extra 25 to the table, so you can kind of negotiate and figure that out. But there's really strict timetables you're going to build in here too. I build in really tight timeframes. Once I get the appraisal, I'm going to send it back to the seller within 2 days. They're going to have maybe 2 days to get me a response, what they're going to do about it. If it's low, then I'm going to have 2 days to get, like, I want it to go, because this is usually late in the process. Like, if we're getting close to the settlement date, like, figure out this appraisal stuff. But you'll never be forced, right, to come up with $50,000 that you don't have. You can get out of it at that point if there's a dispute.
Doug, can you answer the question, what happens if the buyer is putting down, let's say, I'll make it easy, 50% to loan the value, but then the property is like 25% less? I've had a situation where the other side said, yeah, but now since your loan to value can cover it, then you have to stay in the property, stay in the deal.
Yeah, so that's a little bit, and that's usually with like a hard money lender, is that what you're talking about?
No, no, it was just a regular deal, just that the person was not going to pay cash. They putting 50% down, but the property, say we sold it for $500,000 under contract. He was going to put 50% down, which gave a loan to value of $250, but the property appraised for $400,000. So then we tried to lower the price, and they said, no, you really couldn't get out the deal without a bunch of mess because your down payment's going to cover the loan to value number.
Interesting, so. I mean, typically, if you're putting down 50%, the bank's gonna waive the appraisal anyway, because they don't, like, they believe that it's worth at least 50% of what they're doing. But I guess your question is. Are there ways to manipulate your down payment? Like, even if a more conventional amount, can you put down 15% instead of 20%? Does that change anything? And I think the answer is no, because we're still talking about. The value of the property, the overall value. If the property is worth, if you're saying it's worth 500, but the bank is saying it's worth 450.
It's common sense.
Just because you have extra cash sort of available somewhere, like they can't force you to pay more than it's worth. That's what that's just the position the lender's gonna take.
Okay, thank you.
Okay. All right, this is the
let me interject one thing on that. Usually, if you're putting 50% down, the bank probably will go ahead and appraise the property for the value that the purchase price was, even though it wasn't worth that much. However, if you really are concerned about your buyer, if you're concerned about the appraised value, then there's a contingency you can put in the contract. Even though you're putting 50% down, you could say the contract would have to appraise for the sales price. And if it doesn't appraise, then you can get out of the contract. With that,
yes, that's great. That's a great point. So you don't have to waive. So it would be an option. So the lender would say, "Hey, you're putting so much down. Why don't you save the $600 and we don't even have to get an appraisal?" And then the buyer gets to make that decision. Would they rather save $600, or do they want to invest $600 in A, confirming the valuation, and B, allowing them to kind of do this extra negotiation piece? So yes, you can still trigger that.
Yeah, that's what I learned in that process. Thank you for the comment.
Thank you. Okay, real quick. This is the document that you're most often going to use as a buyer agent if you want the seller side to pay for your commission. Right, so typically how it's gonna work now, you're gonna call the listing agent, you have this buyer that's interested in making an offer. You're gonna say, "Hey, love the house. By the way, have you guys had a discussion about cooperative compensation?" I'm not gonna say, and you'll get some insight there. The answer might just be no. But kind of regardless of what they say, you're gonna make the request. And it pretty much says that you have to in the brokerage agreement. You need to try to cover this. So if you want to request 2.5%, you would put. Okay. There's a 1, there's a 2, and there's a 4. 1 plus 2 has to equal 4. So sometimes the sellers will pre-negotiate and say, "Hey, I'm just like, I'm good with 2.5%. Go for it." Like, just so they'll pre-negotiate and they'll provide you with a document that says, "Yep, 2.5% is already contemplated." But if your fee is 3% and you really want that, you could say, in addition to the 2.5% that was pre-negotiated, I want an extra 0.5%. So that would be 2.5% plus 0.5%. 3% equals 3%. 4%, the number 4 is the big one, guys. Seller authorizes settlement agent to pay blank out of the seller proceeds. So that's what you really care about. Usually, in my experience, there's nothing kind of pre-negotiated, or even if there is, they're not providing you with the document. So you're going to use buyer's request for seller's compensation. And number 2, you're going to say, "This is what my fee is. Please give me my fee." You're going to retype it here. And if they sign off, that's what you get paid. Now, importantly, remember, if you charge 3% and the seller's only offering 2.5%, you should still be asking your buyer to give you that extra 0.5%. That's what they committed to. Now, some people don't like it, or there are people that charge crazy fees in my office. And they're like, yeah, the seller's only offering X, like, give me the damn money. Like, this is what we agreed to. This is my fee. So I want you to be empowered to charge your fee. Like, truly, there are situations where you need to waive stuff down, but I don't know. I like my realtors getting paid what they're worth. And I think setting that expectation up front that my fee is 3, it looks like they're gonna offer 2.5. Calculate your books accordingly. Like, we need to make sure that when you send them their, their closing costs, and then make sure it's all broken down so you get paid. Yeah.
So in the buyer's representation agreement, you already pretty much established that you're charging 3%, and pretty much I tell my clients that the buyer, they agree to the 2.5%. Do you think we should write another addendum, getting that signed again, or should we be good with our clients already? Because if we have a conversation in the beginning, letting them know that a lot of times that the buyer might only want to do 2.5, that 0.5% still is owed to, that's gonna come from you.
Yeah, I mean,
Write another addendum.
no, your buyer agency agreement is what controls. That says 3% to your broker. But it's on you to communicate that as things are proceeding, right? So if you're talking to your buyer, like, I'm gonna get the seller to pay for it, I'm gonna get the seller to pay for it, they only paid for half, you better have that conversation instantaneously with your buyer, saying like, hey, look, they're willing to play ball, but you're still gonna owe me X at the table. So we'll just need to sort that all out and we'll get to settlement. Just be really candid about, this is my fee, this is my worth, and make sure there's no surprise. But people just don't want surprises at the closing table. Just avoid that. It's not worth trying to appear sneaky. Just like put it all out there. They already signed it. They shouldn't be surprised.
Hey, Doug, also a caveat to that is talking with the lender, because even though we may hound our buyers and said, you signed off on this, things could change, and we need to talk to the lender to make sure we can still, they can still commit to that, correct?
Yes, so that's a great point. So there's 2 things related to lenders, and then I need to shut this down because my stomach is growling. So yes, if they're suddenly obligated to an extra $5,000 that the lender didn't know they were obligated for, yeah, you better make sure that they have the cash to do that, right? And that's kind of the unfortunate situation where I do see agents at the last second saying, oh crap, I need to reduce my fee because they don't have enough to come to close. So that does happen. So that's a great point. The other piece is, we had a question from the room about, can I just use, a general seller contribution instead of this fancy form? This is why I like this form, guys. It says these payments, so sometimes seller contributions are called IPC, but because offers of compensation are traditionally paid for by the seller, it is the intent of the parties that it should not be considered an IPC. The IPCs are the limits on your loan product, right? So what this document is saying is, we're not messing with your loan product. This is a separate payment by the seller. So if you previously qualified for 6% lender help, you still have that full 6%, and we're not messing with that. And I think that's generally been accepted. So yes, it's important to have that relationship with the seller, and making sure that everything is hunky-dory. All right, guys, I really, really hope this was helpful. I really appreciate all the questions. Clearly a lot of people here that care about their business and want to do a good job. Hopefully I was able to provide some clarity and maybe some of the updates that you hadn't previously seen before. But yeah, go forth and do a great job. And I appreciate you guys.
Thank you.
Thanks.
Appreciate it.
Yeah, great day.
Thank you.